Τώρα παρακαλούμε την Πολωνή συνάδελφο, η οποία είδα ότι πήγε και στο βήμα, να λάβει το λόγο.
Hello. First of all, I would like to thank the organizers for this seminar for their invitation to participate in this conference. It's a pleasure and honor. Thank you very much. And I would like to start with a short film, The Voice of Polish Lawyers.
Dear listeners and viewers from all over the world,
the purpose of this film
is to express our objection
to what is currently happening in Poland.
This is a voice of Polish lawyers of various professions.
Advocates, judges, attorneys, prosecutors,
university professors and students like me.
Our common democratic home is being
dismantled by those at power,
piece by piece,
in breach of our constitution
and the rule of law in Poland.
Our civil and human rights are being threatened.
The lack of constitutional protection,
because our constitutional tribunal is paralyzed, means that it is now
possible to pass any law by the ruling majority.
Even the most irresponsible and the most unwise law.
Such as Holocaust bill.
We disagree with the interference with our
constitutional tribunal, which has become politically dependent.
We disagree with the unification of the role
of the Prosecutor General and the Minister of Justice,
leading to political influence on the prosecution of people who oppose the government.
It leads to political influence on the prosecution of people,
like in communist era.
We disagree with the devastation
of the judicial system
and its independence.
With Minister of Justice nominees appointed as presidents of the courts, people with no experience or stature.
A democratic system cannot force a judge to be dependent on the prosecutor.
We disagree with the political takeover of the National Judiciary Council.
Its current members were ousted
before the end of their terms
and are to be replaced by 15 judges associated with the Prosecutor General.
We disagree with the devastation of the Supreme Court, with the immediate dismissal
of almost half of the Supreme Court judges being forced into retirement at the age of 65,
including the president of a court before the end of her 6 years constitutional term of office.
We disagree with the political dependence of the Supreme Court chamber
responsible for election control.
This is the end of our stable democratic system.
We disagree with the new election rules making election clerks
dependent on the ruling party and allowing elections to be falsified.
We disagree with the political takeover of the national media.
Just turned into a government propaganda machine.
We disagree with the laws allowing the government to invigilate
citizens without due case and court control.
We disagree with the government's offensive attacks on the European Union.
Poles are both Polish and EU citizens.
Europe is our home and EU institutions are also our institutions.
We disagree with the government's attitude to the refugee crisis
and the lack of solidarity with those EU members who are helping.
Our solidarity heritage is being called into question.
We disagree
with restriction of women's rights.
We disagree with the devastation of our environment, blocking green energy solutions,
cutting the last primeval Białowieża forest with breach of EU law.
We disagree with the history politics,
including politically driven changes of museum exhibitions and the falsification of history.
We disagree with the so-called Holocaust bill.
This law restricts basic democratic values,
such as the freedom of debate.
We are proud of many aspects of our history,
but we are also aware of the dark sides.
And who is to judge this law now?
A politically dependent constitutional tribunal?
This film was prepared by Free Courts organization. It's non-governmental organization with cooperation of solicitors, attorneys, notaries, professors of law, and of course judges. This is the voice of Polish lawyers. Let me start. I'm a judge. I'm not barrister, solicitor, and also a lawyer. I'm also assistant professor at Silesia University. And I would like to start my lecture with the words of the former Polish president of Supreme Court. What is independence? Justice is the basis of the states. and impartial justice can be only imparted to the judges who are truly independent. The independence of judges does not exist when it's provided by law on the paper, but only when the whole set of conditions in which the judge works consists in a guarantee of true independence. When the judge is in the general state hierarchy so placed that nothing from the government doesn't he expects, and is not afraid of anything, that he can quietly, without any personal risk, sentence, as he is told by the law and conscience. We can say today that in Poland, unfortunately, not everyone understood this principle. Of course, the autonomy and independence of the judiciary has always been perceived as a necessary and fundamental condition for the proper functioning by the system of justice. The autonomy of courts and its independence of judges with simultaneous administrative oversights by the executive branch have for many years been one of the most sensitive problems of the judiciary. Not only of Polish judiciary, but in judiciary and European countries. I try to discuss the process of dismantling of the free courts in Poland. Two preliminary remarks are necessary in this lecture. The first remark pertains to the fact that although I will be discuss only exclusively the organization of the changes in judiciary and its impact on the judge position and procedure in Poland, I have to speak about regulation according to the Constitutional Tribunal, to the National Council of Judiciary, to the Supreme Court, and also to the Common Courts. Amendment to this law without amending the Constitution, I mean to the Constitutional Tribunal, to the National Council of Judiciary and the Supreme Court and also the Common Courts, have a direct impact on the independence of courts as adjudicating bodies, while changing the political system of the state. In particular, the changes with respect of the law on the organization of common courts and the act of the Supreme Court, as well as an act of the National School of Judiciary and the public prosecution, create a concept of new judge dependent on political authorities by design. This is done by the way of modifying existing principles for taking and holding the office of a judge. The principles of professional advancement, retirement, disciplinary procedures, as well as the distribution of the competences with respect to organization aspect of the work of courts and judges. And I would like to start with EU perspective, because from our point of view, I mean from point of view of Polish lawyers, I might say that today without EU we have authority system today. I would like to start with judgment of Court of Justice dated on 27th February this year in the case Asocialo Sindigas, or if my colleague wants to speak about this judgment, I can, yeah? Okay, so I can, I would like to say only one thing, that from the Polish point of view, this judgment is very important. Why? Without details, maybe, what this judgment means to Polish situation. This judgment into Polish situations means that Contrary to the certain arguments raised in Polish public debate, the Court of Justice clearly recognized that EU law has and EU Tribunal has clear competences based on the treaty to evaluate functioning of the judiciary in European member states, and in particular to evaluate whether the body in light of applicable regulation is a court in understanding of European law. It's a general concept that can be used, and general mechanism that can be used to any country of European law. And being honest, we hope that this mechanism will be used in Polish cases. So, Polish regulations and changes in Polish legal order. According to our situation, the foundations of the judiciary of the Republic of Poland are anchored in the Constitution. The network of the courts has been specified in Constitution. It consists of the Supreme Court, Common Courts, Military Courts, and Administrative Courts. The detailed rules of the organization of the judiciary and their internal organization structure have been left for regulation by statutes. Statutes are passed by ordinary majority in parliament. The Polish constitution, however, introduced a ban on creating extraordinary courts or on introducing ad hoc proceedings before the courts. But the Polish constitution permit to regulate the court organization by the statutes. It also confirms a constitutional rank to the right of each individual right to a fair and public hearing of his or her case without undue delay before a competent, impartial and independent court. In the Polish legal system, there is a presumption of the competence of common courts. These courts have jurisdiction in all cases except of those which have been expressly reserved for administrative or military courts. On the other hand, the different courts remain structurally dependent on each other. The principle of judicial independence of judges in Polish legal system directly becomes from constitution, and representatives of doctrines recognize it as one of foundations of Polish justice systems. In Poland, we say that in practice, the independence of judiciary and judicial independence of judges are directly shaped by principles of appointing judges, principles of promoting and delegating judges, also the principles of responsibility to judges, principles of internal and external administrative supervision, as well as judiciary supervision, regulations and competences of judicial self-government, and principles pertaining to court administration. As it's commonly known, the recent years have been a time of very intense transformation in the system of justice in Poland. The reforms, which first touched the Constitutional Tribunal, then prosecution, then common courts, and finally National Council of Judiciary and Supreme Court, have been justified by the general ineffectiveness of system of justice and lack of public trust in the system. All of these arguments were used by government as legitimizing the changes enforced in the system of justice. These changes have to a great extent related to actually the manner and the scope of regulation of the competence of the Minister of Justice. The President, the present scope of the regulation and the competence of the Minister of Justice in the system of law creates in consequence a rather complicated assembly and competences bestowed of this body in reference to the bodies of the judicial system. But let's start from the beginning. As it follows to this lecture on how to dismantle a democratic rule of law, the first was eliminated the Constitutional Tribunal. Against the law, the ruling of our Constitutional Tribunal were not published in 2016. They were published 2 years later after the statement of the European Commission. And it was done with the violation of the Article 24 of the law of the Constitutional Tribunal. The President refused to take the oath from the judges that have been elected properly and were thus not allowed to adjudicate. So, starting from the beginning, our problem with Constitutional Tribunal is that we have judges that were elected properly and they cannot adjudicate because the President of the Republic of Poland decided not to take the oath from them. And the same, I mean the lower chamber of the Polish parliament elected other judges in their place, referred to as stand-ins. We called it judges doublers. They themselves said that they represented the government because on one conference one of the judges said that he's here as a representative of the government, of the Polish government, the judge of the Polish Constitutional Tribunal. 3 other judges who had just been elected still are not adjudicating, and the new president of the Constitutional Tribunal or a person whom she had appointed as her substitute with no justification shuffled the panels of judges, especially considering the cases to their own like. For example, this concerned the last complaint lodged the National Council of Judiciary regarding to unconstitutionality of the provisions on the creation of new National Council of Judiciary. So, President of the Constitutional Tribunal decides out of the system who should get a particular case, which is important from the political point of view, yes, and changes the panels, yes. So at first we have one panel, and President of the Constitutional Tribunal decides that we should have another panel consisting from another judges. The new judges themselves examining the cases pertaining to lawfulness of their own appointments. They completely ignoring the principle of nemo iudex in causa sua, The President of Constitutional Tribunal expressed her own opinion on the constitutionality or legal acts on public television before the judgment. So we have a case in Constitutional Tribunal, and before the judgment, the President of actual Polish Constitutional Tribunal came to the television and said, my opinion, this case is. What can I say more about the Constitutional Tribunal for today? That it all results that the constitutional organs such as Ombudsman, like National Council of Judiciary, the first President of the Supreme Court, withdraw their constitutional complaints from the Constitutional Tribunal, seeking that it became a facade institution. At present, nobody in their right mind would see the Constitutional Tribunal as a guardian of the constitutional, but rather as a highly politicized body. Another reform take the common courts. What changed? At first, changed the supervision of the Minister of Justice. In Polish system for today, the Ministry of Justice is General Prosecutor, manages the finances of the common courts, supervises the courts, appoints the assessors, and also have a huge role in disciplinary proceedings by appointing the disciplinary prosecutors. He also can be a party in any criminal or civil procedure. So we might say that he has competences in any branch of law. What have been done with common courts more? I must say that they've changed the regulation according to the presidents of court. As many as 130 court presidents have been removed from their office before the end of their tenure. And new court presidents have been appointed by the Minister of Justice, because we have a new regulation which allows Minister of Justice remove all the presidents without any reason from their position for 6 months. Starting from this law came into the force. What is next? The next are disciplinary proceedings. The new solution expands the apparatus of prosecution of disciplinary proceedings against the judges and other members of legal profession under the control of Minister of Justice, granting him a significant influence on the disciplinary courts. The Minister of Justice has broad competences with respect to appointing disciplinary prosecutors and judges of disciplinary courts, as well as influencing of any disciplinary proceedings. They also create a special fast-track proceedings. During this track, the proceedings have to be complete within 25 hours to judge. We say that this special disciplinary proceedings is even worse in Polish system than to normal criminal proceedings, because in normal criminal proceedings the procedure have to take 48 hours. In our proceedings, it is possible to take this procedure during the 25 hours, so less than in normal criminal proceeding. What is worth to underline, the Minister of Justice has obviously been granted also the full right to choose a disciplinary prosecutor for the judges of common courts, as well as two of his or her deputies based only on his underlined unlimited discretion power. So he can just choose, I want this guy as a disciplinary prosecutor, and we might say in practice that disciplinary prosecutors are prosecutors because they are already nominated, and these disciplinary prosecutors are not judges but are prosecutors. And please remember that our Minister of Justice is general prosecutor, so they are completely under the Minister of Justice. The current practice. The current practice in the functioning of disciplinary proceedings is as follows. Proceedings are instituted for conducting education activities by judges. We have the disciplinary procedures as well for the asking the questions to the European Court of Justice, and it's true that we have free disciplinary proceedings to judges only from this reason, because they put the preliminary question to the European Court of Justice according to the actual situation of judiciary in Poland. And we don't have the disciplinary proceedings according to my former speaker for corruption, but for putting the questions to the European Court of Justice, but for the educational activities made by judges or study visits in European institution. We also have the disciplinary proceedings for the study visit in European institution. I mean European institutions like Commission, like Parliament, or European Court of Justice. What changed? Maybe faster. We have a new structure of the Supreme Court. About disciplinary proceedings, I told already. We have extraordinary complaints. This is extraordinary remedy. By this remedy, we can touch every judgment 20 years back. So it's completely new institution, and from our point of view, it's pointless institution. And we have new institution lay judges in Supreme Court. Our Supreme Court, it's court of the law, it's not court of the fact. And it's unknown in Europe that lay judges decide of the law. So we have like that judges in the Supreme Court who decides on law. Conclusion, from Polish point of view, I don't have a time to tell you about the National Council of Judiciary who decides who will be a judge and about the procedure, but what can I say? I can say that we changed the manner of electing the members of this body, and the judicial part, which should be elected by judges according to the Polish constitution, it's elected by the politician. So it's still against the Polish constitution. Conclusion. Our present situation, from my point of view, is actually one which there is no longer a threat, but an actual violation of the system of check and balance by representative of executive power. And you will ask me, it was a question put by the German judge in Krakow in conference exactly 1 year ago, because we have in December 2017 the conference in Krakow. And one of the German judges put the question, we must answer the question, what can be done whenever higher standards of the right to the court are clearly violated by member states. And what is the answer? I think that it seems that for today we might think that it's only a Polish problem. It's not international problem, but it's not true. In this situation, from my point of view, we all lose in this situation. Poland lose, but also lose the Europe. It is not yet too late to stop the destruction of Polish European courts. All we need is European solidarity, and I think this is our common task. The question about the independence of Polish judiciary, it's not a question about the Polish justice system exclusively. It's a question about the position of European justice systems 10 years from now. Thank you very much for your attention.
Ευχαριστούμε πολύ την κυρία Καταρίνα Γάιντα για την εισήγησή της και κυρίως μέσω αυτής για το θάρρος το οποίο έχουν επιδείξει οι Πολωνοί δικαστές ένα μεγάλο χρονικό διάστημα. Δεν είναι δηλαδή πολύ πρόσφατη αυτή η επίθεση, είναι συνολική, έχει όπως μας εξήγησε πολλές διαστάσεις και αυτό το οποίο νομίζω πρέπει να συγκρατήσουμε στο τέλος είναι η έκκληση την οποία έκανε στο κλείσιμο της εισήγησής της, γιατί πραγματικά το πρόβλημα δεν είναι αποκλειστικά ένα πρόβλημα που ισχύει στην Πολωνία. Ξέρουμε πολύ καλά ότι κάτι αντίστοιχο έχει γίνει στην Ουγγαρία και μπορεί, δεν αποκλείεται καθόλου, να συμβεί και αλλού. Εκείνο το οποίο νομίζω πρέπει να προσέξουμε είναι επίσης η θεώρηση η οποία υπάρχει και στο πλαίσιο των σχέσεων ενωσιακού και εθνικού δικαίου σε ό,τι αφορά το ζήτημα της υπεροχής του ενωσιακού δικαίου. Και ίσως τα παραδείγματα αυτά τα οποία βλέπουμε στην Ουγγαρία και στην Πολωνία κάνουν και εκείνους οι οποίοι θέλουν να κάνουν μία διάκριση σε ό,τι αφορά το αντικείμενο της υπεροχής στο εθνικό δίκαιο μεταξύ του επίπεδου των νόμων και του επίπεδου του Συντάγματος να αναλογιστούν τι σημαίνει αυτό στην πράξη, γιατί και συνταγματικές πλειοψηφίες μπορούν να προκύψουν. Στην Ουγγαρία, για παράδειγμα, το κόμμα το οποίο κυβερνά έχει εδώ και 6 χρόνια την απαραίτητη πλειοψηφία για να πραγματοποιεί αναθεωρήσεις του Συντάγματος και όλες αυτές οι μεταρρυθμίσεις έχουν εισαχθεί με διατάξεις του αναθεωρηθέντος Συντάγματος. Έτσι λοιπόν χρειάζεται πολύ μεγάλη προσοχή πριν ακολουθήσουμε τέτοιες γραμμές ότι ναι μεν το ενωσιακό δίκαιο υπερέχει αλλά δεν μπορεί να υπερέχει του Συντάγματος, διότι το Σύνταγμα είναι εκείνο το οποίο μπορεί να καταστήσει το ενωσιακό δίκαιο ικανό να υπερέχει. Δυστυχώς πρέπει να πει κανείς, εδώ υπάρχει και μία πλούσια συμβολή της γερμανικής θεωρίας και κυρίως της νομολογίας για μία αντίληψη η οποία σχετικοποιεί τα θέματα, βλέπει κανείς που μπορεί αυτό να οδηγήσει και είναι πάρα πολύ ενδιαφέρον, το πράγμα το οποίο δεν το ανέπτυξε η συνάδελφος, είναι όμως στην γραπτή της εισήγηση και είναι και κάτι το οποίο θα έπρεπε και εμάς να βάλει σε σκέψεις, ότι υπάρχει αυτή τη στιγμή μία τάση δίωξης εκείνων οι οποίοι πραγματοποιούν προδικαστικές παραπομπές στο Δικαστήριο της Ευρωπαϊκής Ένωσης. Δηλαδή πράγματα τα οποία είναι αδιανόητα. Γι' αυτό θέλει πολύ μεγάλη προσοχή, διότι έχει τεθεί ένα ερώτημα στο μεταρρυθμισθέν συνταγματικό δικαστήριο της Πολωνίας, που έχει ακριβώς αυτό το περιεχόμενο. Εάν επιτρέπει το πολωνικό σύνταγμα στους εθνικούς δικαστές να υποβάλουν ερωτήματα με το 267 της Συνθήκης για τη Λειτουργία της Ευρωπαϊκής Ένωσης, όταν θίγονται κανόνες που έχουν σχέση με την δικονομική, με την ρύθμιση των δικονομικών καταστάσεων στο κράτος. Εκεί μπορεί να φτάσει κανείς με την επινόηση αυτών των διακρίσεων. Γι' αυτό πολλές διακρίσεις δεν χρειάζονται, τα πράγματα πρέπει να είναι απλά. Το ενωσιακό δίκαιο πρέπει να υπερέχει και είναι αυτή τη στιγμή η μοναδική διέξοδος και ελπίδα που έχουν και οι Ούγγροι και οι Πολωνοί. Γι' αυτό λοιπόν θα παρακαλούσα γενικότερα να σκεφτούμε αυτά τα ζητήματα και να μην τα προβάλλουμε θεωρώντας ότι φύγεται έτσι η συνταγματική μας ταυτότητα ή η εθνική μας ταυτότητα ή η συνταγματική μας τάξη.